Hi, everyone. It's Grant Abbott speaking. We've got Mr. Tim Munro and also Tony Anamourlis. How are you guys?
Good.
This is
Thanks, Grant. Hi, everyone.
Hi. This is going to be an exciting session. If you've got Q&A, make sure that you just put it in the chat. And we've got Tony and Tim going to be there, and we're all online. So this is an exploratory session. So we had it down to show you some new features in our wills and EPOAs, but what I've done is I've been doing quite a bit of work with Tim and also Tony in relation to the establishment of testamentary trusts and also living trusts. And we're going to go through a lot of that sort of stuff as well. Tim, if you can also put up next week, we've got our Change GPS Trust Deed Week. If you can put that into the chat room, and do you just want to give a bit of a shout out about that Trust Deed Week, because I think it's pretty exciting. Sure. How many people are going on it so far?
We have just got 600 people registered for it at the moment, and we reckon there might be 700 or 800. It's going to be epic, Grant. It's going to be massive, and the sort of thing that I think that we'll do once a year, because it's just so important. The new people coming into our industry all the time. And the things that we'll be discussing the week are just so crucial. No one's ever done it before. Working up all the slides now, going to finish them on the weekend, and we are so excited. So I'll put into the chat area, just go to changegps.com.au and it comes up splash screen. You go straight into it and register. It's so simple.
Yeah, it'll be fantastic. So if you just chuck that in the chat. Brian, thank you very much for your comment around Kaplan and our training certificates. If you could send a message to Alora, in fact, I'll put her name in the chat room, and then Alora, if you're on, if you could put your name in there so that she can follow up with Lifespan and Kaplan, because we haven't had any issues before. So usually it's just the nomenclature which is sitting on the certificates. It's quite funny actually, because we are an accredited institution with the SMSF Association. So we can hand out CPD hours for the SMSF Association. So it'd be interesting to see whether Lifespan covers
Grant,
that.
I'm with Lifespan, and they've accepted all of the certificates from Lightyear that I've submitted. So you need to put them in the CAP plan, and then in a way that asks for Lifespan to approve them. And then I've had about 30 approved.
Well, there you go, Brian. So it's straight from, I was going to say the horse's mouth, straight from, who's your most favourite driver of every time? Formula One.
Oh, look.
Senna?
No, I look, Senna. Ed Senna. I actually watched it when he died, the poor fellow. Senna was great. Like Webber, obviously, and Ricciardo. I do like Sebastian Vettel. Hope he goes well in the old Aston Martin.
Yeah.
But I want Ferrari to knock off the Mercedes. So yeah,
they're all pretty good. Okay, so let's get into it. I just want to take you through a whole lot of stuff. A really, instead of a highfalutin case study, I'm just going to look at a really basic one, because we need to get you on top of things. Also, I want to give a bit of a heads up and show you what our new site is going to be like. Some of you probably have seen that we've had a couple of issues around a recent update by Google in terms of same site settings, which is essentially how we operate our system. So we've gone to Google and tried to get a patch, but who knows how long that's going to take. In the meantime, if you use Firefox, we haven't had any issues, but we're expecting come September, October, that we'll be in a position of launching. I just want to give you a bit of a heads up. One of the main things that I think is absolutely super exciting, and I've just been watching what's been going on in the background through the beta testing, is that with the data capture that I'm about to show you, you'll be able to send out an electronic version to your clients. They will be able to complete the data capture, which will then go in and actually complete the document for you. So virtually you are not preparing anything. And remember all of that issue that we worried about, Legal Profession Act and all that stuff. I mean, virtually the client has prepared the whole document there. So that's a pretty exciting issue. We'll talk about how Abbott-Family fits in a little bit later on with Mr. Anamourlis. Michael Jeffriess would have been here, but unfortunately We're doing a capital raise at the moment, and we've got a lot of interest. So he's just following up on that, and that goes live today. So for those of you who are looking at getting into our business, it's probably the best time ever to do it. We've just won the Australian Digital Technology Awards for start of the year. Really, you guys should get that next year, Tim. 6th place for the Australian Digital Technology Awards in Wealth and SMSFs. I've also just been nominated as Telstra Small Business Awards Innovative Firm of the Year, which is pretty exciting. And Michael's firm, I Love Accounting, is in the top 3 in the startup section of the Australian Accounting Awards. So, look, I don't even know. I'm not a big awards person, but it's certainly nice to have. What I would say say today, we're going to do a bit of a deep dive and get our hands dirty with the legislation, which I love. For those of you who watched the session yesterday, that prepayment of super, I showed you where we've got a bit of a swipe file. Send that out to your clients, because that's easily probably a $40,000 to $100,000 pickup between now and 30 June, and it's really a no-brainer. I mean, why would you go and get equipment financing when you can actually put money into super and use it for capital investment, unless you obviously need that particular equipment. The one element there, if you haven't signed up for the course, the 3-day course, just make sure you do so between now and obviously the 19th of July. So where you'll actually get a lot of confidence and start building all of this stuff with a lot of case studies.
Grant, what I'd recommend is sign up for that course, prepay before 30th of June, and get your tax deduction for it.
Exactly. Yeah, definitely make sure you do that. It's certainly worthwhile. And if you're a shareholder, you get even discounts on that one as well. So I just wanted to show you this little document wizard. I'll probably get in huge trouble from Ash. So if any of my team on, don't tell her. But anyway, so this is, so you're used to dealing with our system where you go straight into hot docs, which is, let's face it, it's pretty bloody ugly. So this is just a start of a mock-up that we've done, and it'll come up like this for us, so that it's a lot cleaner and cleaner user interface. It also will auto-predict addresses there. Integration will have CAS 360, moving on to BGL, simple, their simple super, their 360. We're then going to Zero Practice Manager. Of course, actually the first one is going to be as straight into ASIC with their new system there as well. You'll be able to also load information from integrations and also previous interviews. So, for example, if you've done an existing will and testamentary trust and you want to do another one, you can actually load up that and then copy, so virtually clone one. So that's pretty exciting. I can do that at the back end of my system, so that from one set of documents you might have a client, you can pull that out and put it in. Put internal notes. There's a whole lot of stuff there as well. So it's going to be a lot better system. So I'm looking forward to that. Anyway, let's dive into the session. So clients come to us, and again, it's not a super sophisticated. I mean, I could go in with different marriages and all that, but I just wanted to show you how this works at a very, very basic level. So we've got John Smith, who's 45 years old. He's a plumber working as a subby, and he's married to Sally, who is 40 years old. They've got 3 kids, Ben, Wills and Mary. So Ben's age 15, Wills is 13 and Mary's 7. So Ben's not that far off being of age 18, where he is now going to be a legally adult. They've got a family home in Cronulla that's got 2.5, it's worth 2.5. It's got a small mortgage. They've been sold in the past a $1 million insurance and TPD policy, which is in the other's name and their children if they're not alive. We've got a bit of money in Australian super, and that John's got 350 and Sal's got 150. And you do know right from the start that their guardian of their children is Sally's sister, Anne Brown. So when we have a look at that, it's very unlikely they've probably done a will, or if they've done a will, it's a very basic one. What we need to do is, when we go through and deal with that, I'm going to show you our data capture shortly, we need to really start with the worst case and build from that. So that if we go and have a look at the facts, so if both John and Sally died yesterday and left Ben, Wills and Mary, what would be the state of play? So you always need to look at the worst case and prepare for that. And really, once you've done that, then it's very easy to build away from that. So first one is obviously, who's the guardian? What are they going to get? So when we have a look at testamentary trusts, we generally don't want the guardian to be the trustee or the appointor. You can have that if it's like a sister, etc., because otherwise they've got full rack and title to all the monies. We tend to use trusts. Trusts are great, and I want to talk about, I'll start to bifurcate our discussion, and then I might drag in Tim on this one. So look, trusts are great for asset protection, obviously, great for family law protection. It's a little bit harder if it's direct, although there are a number of cases around, and we will do a family law session in the trustee week as well. And it tends to revolve around control, whether the trust assets are matrimonial property or whether it's just a financial resource. Always, all the cases I've seen in relation to estate planning, so if a child is a beneficiary of a testamentary trust, there's no discovery on the will or the testamentary trust. It's always going to be a financial resource unless they have full control. Great, obviously, for tax minimisation, litigation protection, family provisions claims, so that if we've got a trust directly, say a family protection trust running, then effectively that's protected from family provisions claim. Compare that to, obviously, if we're building a testamentary trust for our 3 children through the estate, then that's obviously subject to a family provisions claim. Now, it's very unlikely we've got a family provisions claim here. We've got young family. Obviously, they've been, both of them have been married for quite some time. So there's no, well, we don't know whether there's another child lurking anywhere. We're pretty well right. And of course, we can limit it to bloodline beneficiaries only. So it's not only our children, but grandchildren, and everyone can be bloodline. So what we've got there is we've got different sorts of trusts. So we've got here a testamentary trust, but before I get there, I just want to talk about what we're building. So I'm going to show you what I'm doing in my build of the testamentary trust. It hasn't been completed yet. Tony and I have built one for some clients in the past directly through Abbott-Family. But I want to go through and talk to you about the technology and the strategies I'm going to do with this testamentary trust. Importantly, when we do that, if we have a look at a testamentary trust, and let's consider that both in this instance, John and Sally aren't around, then we're going to have to work out who's going to be the appointor, who's the trustee, and we'll talk our way through that. Who the beneficiaries are, obviously bloodline, but more importantly, when do the children come in and take control as trustee and appointor. So all of that's A-OK. So we've got a position there that both John and Sally are out of the picture, and then we're building a testamentary trust for the children. We could even go down the track, and we'll see there, depending on the amount we've got, we could end up with 3 testamentary trusts for that aspect. And a testamentary trust, when we have a look at it, is simply a trust that's created on the death of a person. So when we have a look at that, the testamentary trust we generally see, and we're going to look through the laws around this, is the one that's to be created by the executor of the estate. Traditionally, when you have a look at a will, if you have a look at our LYD wills with testamentary trust, or our LYD will that's got a bloodline trust as an option in there, it provides terms and conditions to insert in the testamentary trust, which is to be created by the executor along with yourself as the person who helps administration on your death. So we need to go through the process of getting probate. Do you just want to go through that process, Tony, just briefly on someone dies, the steps of getting probate, the timing, what needs to be done around the advertisements? I know you're doing quite a few at this present point in time for our accountants and also planners.
Yeah, so what the first step is basically is you need a copy of the death certificate, you need a copy or the original copy of the will. After you've received that, you put your advertisement in relation to the death of the deceased. After 14 days, on the 15th day, you make an application for probate, and there's a number of steps in that probate process that you have to go through. You have to swear up an affidavit. Well, the executor has to swear up an affidavit on all these, points. And after, and you've got to do a list of inventory, personal assets, what you've got in the estate, all that type of stuff. And then once the affidavit has been sworn up, then with each state, of course, it's got its own provisions. What you do is you create an account with the Supreme Court website, under the Supreme Court website, and then you lodge all your documents, pay your filing fee depending on the size of the estate, and then what happens is the probate jurisdiction of the Supreme Court or its registrar will actually assess the application, and if there are any requisitions in place, then they'll send them out to you, and then you'll have to answer those. And then at its final stages, they issue what's called a digital parchment granting probate basically of the will. Then that next step follows on basically is a distribution of the estate. But you've got to wait. Well, in Victoria, at least you've got to wait at least 6 months just in case there's any family provision claim that comes up. Otherwise, if the executor just distributes the, whatever the estate's worth, and then in between that, a family provision claim comes in, well, guess what? The executor, if there's no money in the estate, the executor will personally liable for that. So you've got to really watch it. So there's all these other,
There's also the case, which I think we need to look, and I just want to just show you a different way of doing things before we move on. We are talking about testamentary trusts, which obviously follow out of the estate. So we've got to get probate first before we can actually create the trust, because a trust is, although you might have a document in the will, then it doesn't become a trust until it's actually settled with property. So with that one, there can be some time, as Tony said, at least in Victoria and most other states, a 6-month timeline between receipt of the someone dying and actually the beneficiaries receiving monies. Now, I've seen a couple of instances that have come through to us, Tony, where monies have actually been dispersed before probate. And is that a good thing or is that a bad thing?
It's a bad thing, because what the executor's got to do upon between the time of granting probate and distribution, you got to wait 6 months, but the executor has to open up an account as trustee, as an executor of the trustee of the estate, basically. So all the money gets pulled in into that trust account under the executor. And then you just got to wait, basically, just in case, like I said, just in case there's a claim there. Otherwise, it'll turn into shambles after.
Absolutely.
So really watch
I know you're dealing with a couple at the moment. And look, if there's any of those sort of cases that pop across your desk, just make sure you contact Tony, and we're there to support all our light year group and AM advisors as well. Now, what we're looking at the moment is what would traditionally be called a testamentary trust. So that's one created out of a will. So in our existing documentation, I'll take you down through that, is that we can put the terms and conditions of that testamentary trust embedded into the will. So it might be, for example, we've got a testamentary trust for all our bloodline children, or alternatively, there's quite sizable assets within that estate. And in this instance, we've got $2.5 million or thereabouts being the family home. If that is sold, then we might end up doing a testamentary trust for each child, or alternatively one for the whole three of them. Whatever the client wants. I mean, at the end of the day, the client is the one who is the king in this instance. So with a testamentary trust, again, we can put down the terms and conditions, or alternatively, which is quite often the case, we can build that testamentary trust as part of the will and have all of the trust deed. It's not a trust at that stage, remember, it has to wait until probate before it comes to trust, but we can have that whole document there. So you can have either or. So we're going to add that option to our wills with testamentary trust so that essentially it'll bulk it up to quite a significant extent. So we'll be doing that. Now, the other side of the coin is if I go back and have a look at our family protection trust, which many of you have been building, or your leading member trusts, or even just your plain garden variety discretionary trust, they're also a great way of transferring assets or transferring wealth between generations without stamp duty or capital gains tax. Importantly, from that perspective, if both John and Sally have passed away, again, if you've got that leading member, we need to have that third leading member appointor to come in and take control of the whole process. But then suddenly that trust will be there for the three of them, Wills and Ben and also Mary. What we're doing now is with our family protection trust and also with our testamentary trusts is that effectively, if there's the death of the two main protagonists or the two main appointors being John and Sally in this instance, that there'll be able to be 3 sub-funds set up for each child within that family protection trust. So that's going to be a very exciting development, and we'll go down the track. More importantly, if you are doing upgrades, there'll be an ability, and again, this is going to be coming out and we'll be looking at this in detail at the time of the course. So it's just going to take a little while for me to build. From that perspective is that you'll also be able to choose if you're upgrading or starting or commencing a trust, be able to choose South Australia as the jurisdiction because there's no rule against perpetuities in that one. And even if you've got an existing trust, you can still choose South Australia as an existing jurisdiction. So we've got a testamentary trust, which is a trust on death, which it comes out of the will. The other one you'll see when we get into it is that any superannuation death benefit, which is paid directly or payable directly to a dependent. For example, if it's an adult child, they're financially dependent. A grandchild who might be financially dependent. Remember, if you've done your family allowance agreements, a spouse, then in those instances, and particularly with these 3 children, if we have both John and Sally deceased, then the superannuation for both John and Sally can be put into a testamentary trust. Now, importantly, that's settled straight from the superannuation fund. We'd cut a check and get them to pay it straight into a testamentary trust, but it does not go through the estate. Traditionally, if you have a look at superannuation proceeds, it goes into the estate. Now, when it goes into the estate, what could potentially happen? It's not going to be a drama in this one, but it can be for other ones, is that if it goes over into the estate, then it can get embroiled, as Tony said, in a family provisions claim. Whereas a testamentary trust created with super is not going to be embroiled in a family provisions claim, nor is a beneficiary of insurance benefit. So if both John and Sally die, our agent has got that $2 million, we would direct the life insurance company to pay that directly into a trust that we have established. So you can actually see all along this, accountants and planners, you're going to be pretty heavily involved in that process. Building the trust, is that living trust style where we've got those sub funds, or is it going to be a testamentary trust created from super, a testamentary trust created from insurance proceeds, or is it going to be a testamentary trust that comes out of the estate? We can even create a testamentary trust 3 years after the death of a person. So we'll go through that very shortly. So that's a post-dated testamentary trust if we want to go down that track. Again, is a great opportunity that the law allows us there. So we've got a whole range of trusts that essentially all look after in a different shape, manner and form for our clients. Now, what I wanted to do is just highlight to you now, and we're just going through this process, and I don't think I've shown you this one, Tony, but I've got a couple of things here. So this is a new product, not a new product, a new little ebook that is coming out very shortly. So it's the Guide to Testamentary Trusts, plus a data capture to help establish your own for one or all of your family. So that is going to be in an ebook. You'll be able to send it out to your clients. What we've got there is Grant Abbott. If you want, we're still working out whether we do that. So obviously we'll put Grant Abbott, probably put you in there, Tony, as well. So you can be your little ebook. So that we'll put a picture of you with a hanky on your head and you'll be sweet. But what we'll do there is that if you know, I don't think it'll cost that much, but with the ebook, but if you want to put your name on there as an author along with me, and you're one of our strategist members, please feel free to do so. Let us know. But this will be out next week. We're just getting it professionally formatted, put an ebook or ebook style. So much the same way as you can give your logo, Tim can come on and just say it's Grant Abbott, Tony, and Tim who've actually drafted this up. And it'll continue to be improved. So I won't go into it. I'll send it out to you actually in a couple of days so that you can have a good look. A few of our advisors have already had a good review of it, but we just go through what a testamentary trust is, what it looks like in practice. We've actually got John and Sarah there, how it works. These are the sort of some of the issues. For example, beneficiaries are Jacob and his bloodline, but do not extend to his latest de facto. So have a really good look at that. Pros and cons in your will. So we go through all the benefits, obviously the CGT, the tax for minors, etc. We also go through all the drawbacks, which I think is absolutely crucial to go in there, and then a whole lot of Q&As. And I would expect over time that is going to blow out. So we've got the book there, and then we've got the data capture. Let me just insert a page break on that one. So with the data capture there, we've got a bit of an explanation of that interview process, and bearing in mind that as this goes down the track, if it's an ebook, we will be able to pick that data up and hopefully put it into our new system. But when we have a look, there is Bloodline Focus. They can tick, you know, do they want to make sure it's for bloodline or not? If you go yes, then obviously it's going to charge more. So their own name and address, all the common parties, the children, relationship, executors, etc. will go in there. Who's to be your executor? Ensure their details in the common parties above. So it could be John Smith, blah, blah, blah. And then the successor executor and the second successor executor. Now in the Testamentary Trust. So what we've got here is a little bit of a data capture, and I've given an example here for a sample. So let's just go through. We'll be looking at making specific gifts such as jewelry, a car, a cash or property to a specific beneficiary soon. After that, we'll look at sharing up the residue of your estate amongst designated beneficiaries. This may go to them directly at their option into a TT or a TD, which must take for their protection. Before we get to that, consider the TT options that you may want for either the family or specific people. Just insert the details that you want in the boxes below. And when it comes to specific gifts or residue, just name the TT as being the recipient, and we can do the rest. So for example, there, let's have a look at, we've got the son of John Smith, and we've got Max Smith. This is his trust. So John has got inside his will, TT, that he's going to create for his son. So it's the Max Smith Family Legacy Trust. Who's the first appointor? It's Max Smith. Who's the second appointor? Bill Smith when he turns 18. So you can see it's very topical to round our case study. Who's the trustee? Set up a company with Max and Tim as directors. Beneficiary, Max and his bloodline children. If they're none, then his brothers and sisters. Terms and conditions for beneficiary. Any beneficiary under the age of 25 is not to receive a capital distribution. Does to acquire property, pay for medical or educational expenses. Additional terms and conditions, I love this one. Any beneficiary to not have a drug or alcohol addiction is to have treatment paid from the capital of the trust. Probably should put a sex, no, we'll just leave it at drug and alcohol. Anyway, so when we have a look there, the Testamentary Trust, We put in the name, and then what they do is they just follow this. So it might just be, for example, the Smith Family Testamentary Trust in this instance. Or alternatively, we could put in there the William Smith Testamentary Trust, or the Smith Children Legacy Trust, or the John Smith. So what we do is we can go through that, and then you'll see then we've got the ability to complete the rest of the estate. So we've got specific gifts there. So the name of the person. So if the gift there is, for example, such and such a property, so it might be, for example, farm at Dubbo, and you give all the details there. We then might go over here, and that's to go into the Max Smith TT. And that Max Smith TT has already been, all the terms and conditions have been built up there. Does that make sense, Tony? Or
Yep.
Yep, that's good. I always use Tony as my sounding board just to make sure that I'm not losing anyone from that one. And so they can go through each specific gift and then just reference it either to the individual themselves, or they've got the TT up there. So we want to get them to build the TT and then make those options. So then we go through the remaining estate. We've got the name of the person. Again, it could be, again, a TT there. And then also the thing, if they're not alive, what's going to happen there. So we can, again, put that into their Bloodline Children, a Testamentary Trust. Secondary beneficiaries. You may not have seen it, but we've got excluding a person or limiting their benefits. So, for example, if there is and this is getting a bit more sophisticated, if, for example, you're giving your two children $500,000 a piece, and then your de facto spouse only $35,000, expect, as Tony said, there'll be a challenge. But we could put in there the reasons why, because we've given her a house or given him a house or whatever. So that's now encapsulated within the will. Funeral wishes, child and pet guardianship. So for the children, the three children there, it's going to be Anne, I think it's Anne Brown, and then we need to have a second guardian if they're alive, pet guardianship. Life tenancy, again, this is a trust. So if they understand the testamentary trust, then you can do the same with a life interest trust, SMSF wills, and that's essentially it. So that's all going to be part of that book, the Guide to Testamentary Trust, and we'll bulk that out over time. But it's a really good way of getting your clients' focus in on building that data capture. So what do you think about that one, Tones?
Love it.
Yeah, it's just nice. Got our favourite gold as well. Here's a copy of a testamentary trust that I'm working on at the moment. I'll have probably next week by the time we get to Trust Deed Week, I'll have the first blush of this. And then once I do, so we're all of this starts obviously on the death of a person, once you've got the family provisions, and we set up the testamentary trust. What I'll be doing though is you can see down here in terms of when we go down, we've got beneficiaries, income, capital, distribution of capital. Till the trust is wound up, the trustee shall stand possessed of the capital of the trust for the beneficiaries as follows. On or prior to the termination date, the whole or any part of the capital or any category thereof shall be held for such one or more of the beneficiaries to the exclusion of the others, blah, blah, blah. So what I'm going to do is be building into that the ability to have a schedule at the back, for example, Schedule 1, that has, for example, the terms and conditions that we saw down here in the Testamentary Trust, if that makes sense. If I have a look at the Max Smith Testamentary Trust, so that will be built into the schedule. They'll be able to, not for example, if just John dies or Sally dies, but if at the end they both die and there's a testamentary trust and they want to create, so this is for a family protection trust or whatever, there's going to be 3 separate sub-funds there. So that's going to be an exciting addition next week as well. And I've got to also, for my good friend Milton, work on a hybrid trust, which I've worked on as well. So what we've got there is we've got a really good format. Again, feel free, Tim, if you want to use that Guide to Testamentary Trusts and put it up on the Change GPS site. Again, it's a really good data capture for that as well. Now, I know you've gone through the process or going through the process of doing that moat and castle for yourself, with obviously both yourself and Lindell, if you both pass away, what's going to happen there? So worst case scenario, so you've just got Savannah. How have you built your testamentary trust for that?
So what I've done is I've built it that if anything happens to me, and look, I don't have assets in my name because we've got everything in companies and trusts, and I've upgraded them all to leading member style. But at the end of the day, money flows back somewhere. So anything that might be in my name and might flow to me, I've given to Lindell, but testamentary trust at bloodline style to Lindell as the primary beneficiary. And Lindell does the same back to me, again, testamentary trust, bloodline style, because I don't want any assets in my name, because I'm a risky person as a director of a company. If both of us die, then Savannah gets everything again in a testamentary trust, bloodline style. But if the three of us go, what I've got is I've got my mum and Lindell's mum and dad, and then my two brothers and Lindell's two brothers. So I'm actually having a tertiary beneficiaries, equal amounts to all of them. So there'd be 1, 2, 3, there'd be 6 in equal amounts. And again, I'm using the option to have it in testamentary trust for each one of them.
Fantastic. So as I said, the next variation of the testamentary trust we're coming out, you'll have the option to just have the terms and conditions as you do now, or you'll actually be able to prepare a whole testamentary trust if you want, so they can sit in there. Although it does get a lot more difficult with that one, because if you end up a tertiary beneficiary, you can end up with 20 testamentary trusts. So my preference is obviously do it at the time of administration. Now, the whole process about this is really, from my perspective, is we've had lawyers go about it in the past. And the problem about the lawyers is they'll do everything through the estate. And the danger about that is, of course, it's going to be subject to potentially a family provisions claim, or if there's a trustee in bankruptcy, obviously the first thing they're going to latch on is to the estate. One of the things that most accountants really miss out on is that the testamentary trust, or any trust for that matter, needs to be administered. It needs to be established, and then it needs to be administered. So I want to have a look at section 102 AG of the 1936 Income Tax Assessment Act, which talks about accepted trust income for minors. So that means that, in effect, where we've got a trust, this style of income distribution comes out, that the minors are just taxed as adult beneficiaries. So the first one, and this is the sort of stuff that we'll be looking at, this and rulings and guidelines and cases on that 3-day extravaganza. If you can make it, make sure you do. But subject to this section, amount including the assessable income of trust estate is accepted trust income, which means it's not subject to the penalty taxes for minors. In relation to the beneficiary trust estate, to the extent to which the amount is assessable income, and this is a new area of a kind covered by subsection 2AA, and I'll talk about that in a second, of a trust estate that resulted from a will, codicil, or an order of a court that varied or modified the provisions of will or codicil, or an intestacy, or an order of court that varied or modified the application, so on and so forth. So you can see this subsection 2A deals with trusts that are created from the will. Does that make sense? So it could be the family provisions claim could fight in there. And you might have this most beautiful testamentary trust, but if it's all subject to family provisions claim, you just don't know what you're going to settle into the trust. So I might put in there, for example, $1 million is to be settled into the trust. But if there's a family provisions claim that whittles that down to only $200,000 by way of an order of the Supreme Court, then we just have to deal with $200,000. So you just got to be careful also when we're drafting up whether we're quite specific about the amount, or alternatively, do want to put a condition in there. There's got to be a minimum amount before we actually set these up. Of course, once we do this, you'll see one of the issues is that there's a lot of benefits in there. And one of the benefits is you'll be doing the administration of this. Now, what we have to look at is assessable income of a kind. So now what we had before is without that elaboration, which has only just come into law in the last year. Prior to that, we'd have a testamentary trust where we'd have the children of that estate, in this instance, the 3 children. The money would flow in And obviously when the income comes out, it's just taxed as ordinary adult rates. But of course, people work their way around that, and they would seed other assets going into that trust, or they would seed other income streams going into that trust in order to take advantage of that particular, those particular rates. So now with 2AA, it's got, for the purpose of paragraph 2A, assessable income of trust is a kind covered in this subsection if the assessable income is derived by the trustee of the trust estate from property, and the property satisfies any of the following requirements. The property was transferred to the trustee of the trust estate to benefit the beneficiary from the estate of the deceased person concerned as a result of the will, codicil, and testacy. The property represents accumulation of income on that, and represents accumulation of income or capital for property. So you can use that trust for multi-income, but it means you as the accountant will have to separate that into a separate sub-fund, and then obviously income, accretions to income, when they're paid down, then minors will be benefiting from that. So generally it means that those testamentary trusts generally won't have that other income now, which is important. So we've got the 3-year rule that I talked about. It's derived by the trustee of the trust estate from the investment of any property that devolved for the benefit of the beneficiary from the estate of the deceased person. It was transferred to the trustee for the benefit of the beneficiary by another person out of the property that devolved upon that other person from the estate of the deceased person. It was so transferred within 3 years after the death of the deceased person. So that's our 3-year rule. And the other one here is, if we have a look at section 2C, it also has a whole range, and I've just picked up a few. So it's derived by the trustee of the trust estate from the investment of any property transferred to the trustee for the benefit of the beneficiary, directly as a result of the death of a person and under the terms of a policy of life insurance, if that makes sense. So we could, of course, get the life insurance and put it into the testamentary trust in our estate. The only problem about that is, of course, it's going to be subject to what? A family provisions claim. Whereas in this instance, we can set up a trust with our insurance proceeds, and effectively those insurance proceeds trusts are effectively accepted. So it's all going to be assessable. It's quite interesting when we have a look at this, that 2AAA or that 2AA doesn't apply in this instance because it's quite separate. Directly as a result of the death of a person and out of a provident benefit superannuation or retirement fund. So again, if we've got superannuation, we can just pay that out directly into a testamentary trust. So they're the cases. Tony, just want to go through, because I know we keep on getting this question, but just want to give a bit of an update on the 3 areas of, obviously the first tier 1 is where you are preparing it from a data capture, etc. Obviously the client's responsible, etc. You not covered, the documentation itself is covered by AM, but obviously the preparation's not. Tier 2, you just want to go through that. We've got there where we're preparing wills and EPOAs for mum and dad. But if you're doing the moat and castle with SMSF wills, we're coming in. I think this is a very, very inexpensive fee.
Well, it's an inexpensive process from our side, right? You go down the tier 2 route, at the end of the day, you get everything. You probably end up getting like 3 Zooms rather than 2 Zooms, because the client may want some extra stuff inbuilt, within their document or within their will or EPOA. So it's a very inexpensive process for us, right? As I know, I mean, if you were to do something of this caliber, let's say, your wills with TTs, EPOAs, medical directives, all types of other things, you'd be up for about $3.5 grand. I know that, right? Because I've done it before. So that's 2.5 for each will make I'm talking about, yeah. So you're looking at about $5 grand here.
Yeah, so this is a pretty good, this is great value for a family. So what we're doing again, AM is there to look after accountants and planners and, make sure that we're overseeing your work. And as you can see, it's AM mentoring. So you'll get the data capture, you'll get all the information, you'll prepare the documentation up to a first level. You'll then give us the code for it, or the ID reference, which is sitting in the Lightyear Docs site. And then what happens is we then start to go to work. In fact, we do probably about 2 or 3 a day at the moment with Tony. So you go through, we'll look at that. We'll then cover it the first Zoom with the client. We'll go through and make some changes. And then what we'll do is we'll then go and draft the next will. So I think that's very inexpensive. For those of you smart enough, I'd be using the Moat & Castle, because there you get your EPOAs, you get your SMSF wills, and we can also look at things like family allowance agreements, etc. So, you know, that to me is really good value. You just need to say, okay, well, if you're doing a Moat & Castle, all of that, you should really be charging $5 or $6 grand anyway with all those documents. Tier 3, Tony?
Tier 3 is more based on referral, 30% administration fee. So it's normal. We do all the work. If you know, if the advisor doesn't want to get his or her hands dirty at the end of the day, so the advisor passes on the client. We set up the Zooms. We do all the work basically in terms of the documentation. We do all the amendments, we do all the reviews, but the advisor is always on with us to make sure that he's on top of it also, to make sure that what's going on. And yeah, so we charge a fixed fee after that. And then there's a 30% administration fee back to the advisor basically. So that's pretty straightforward.
So if we go back here, and then I'll go into our system just to show you quickly. Again, so the first port of call is obviously sending this out. But if I go back into our slides and have a look, our case study. So what we've got here is we've got for the family home in Cronulla, we can, if something happens to both John and Sally, then we can create obviously testamentary trusts for the 3 children if we want. Now, it's unlikely there's going to be a family provisions claim, so we can then roll in the insurance and roll in the super into that one as well. Now, if John had had a prior wife and there's a potential of a family provisions claim, then what we may do is the reverse. We might have a separate testamentary trust that holds the insurance and the superannuation. So the settlement, which you'll create, is as soon as you get the super, which hopefully is fairly quickly, you'll put it into a testamentary trust or a legacy trust that's created for the 3 children. And then when you get the insurance, you'll do the same thing, put it in there so that you keep that away from the estate. But if there's no family provisions claim, then you'll put it all into that one testamentary trust that's created by the executor. Now, of course, the reverse is that's the worst case scenario. And Tim's already sort of given you an idea of what happens in his instance. But for example, if just John dies, then we can have Sally should have the option of creating a testamentary trust, obviously for the tax benefits for her children. So that makes sense. And again, if there's no family provisions claim, we put everything into that one testamentary trust. If there looks as though there's going to be a family provisions claim, so there's an ex-spouse or whatever, then obviously with Sally would receive the insurance proceeds and also the superannuation, and I'd put it directly into a testamentary trust outside the estate. Now remember, the nomenclature should really be there's an estate testamentary trust or there's a non-estate testamentary trust, and that's really crucial around that one as well. So I've just got, I'll just jump in here. I've got a little one that we worked on.
Grant, can I just ask a question for that?
Yeah.
If you've got people that have had a relationship that has finalised, they've split, family law court stamped, and they've had a settlement.
Yeah.
Post, if someone dies, can the former spouse come back and have a crack again?
Absolutely.
Wow, that's
Yeah,
massive.
so, yeah, it's one of the, if you have a look at it, we've been dealing with a couple on that. There's been a couple of cases. The funniest one I talked about is a guy been married 3 times, and again given monies to his first his children, left out his wife, etc. And obviously the no win no fee lawyers try and rustle up as many people as they can because they get 30%. They went back and had a look. 25 years ago, he'd been married to a Filipino girl for 2 years, and then the marriage broke up because she was actually married to someone else in the Philippines. So she'd actually been a bigamist, but effectively he did have an entitlement on the estate. To the extent possible, again, you say, well, that's ridiculous. He hasn't seen it for a long time. But there was another case in West Australia recently where a child had been estranged from their family for 30 years, was able to up their legacy from $10,000 to $100,000. So again, these family provisions claims, if you think that's the case, Tim, that's where the protector, that family protection trust, and that's where the work I'm doing now is to make that family protection trust for those children. I think you and I have discussed it, that we'll be able to have separate schedules for each child, which will have those terms and conditions. So when we have that capital, it'll be split separately amongst that. Although it'll only be one trust, of course, there'll be the ability to just take that money out and set them up in their own family protection trust. But we want to have both options there. So that's what I'm working on at the moment.
I've got so many clients that are after that. The clients with a little bit of money, and they want to make certain that things are going specific ways. So, so looking forward to that.
Yeah, definitely. And look, we're dealing quite a lot with the fact so many people have been married before. They've gone through nasty divorces. They want to make sure their ex-spouse doesn't get anything. So again, once you start doing that, your testamentary trust is great, but it's leaving open the windows. You really need to go down that family protection trust. And the beautiful thing about the family protection trust, which is what Tony was saying before, is that on death, if you want to pay money for the funeral expenses, if you want to pay out a bit of money to, the family or whatever, you can do that straight away. You don't have to wait for probate. You don't have to wait 6 months. There's no challenge to the estate. So it's a better way, and it's typically the way that they do it overseas, because then there's no death duties on that trust. And we'll go that way in Australia, because there's no way we're going to not have death duties. I can tell you the millennials, once they come through and take control as politicians, you know what they're going to be doing. They're going to bump death duties on all their grandparents. So watch out. Cynical, absolutely, but that's what life's about. Okay, so I've got here the Smith will with Testamentary Trust. You can see here I'm using Firefox, which works in exactly the same way. As I said, there's no problem with that one. You can see we've had this session expired up as well, so bloody Google, but it won't have a problem with our new suite. So I've just got the Smith will, put all the common parties. I've got John and Sally, Ben, William and Mary. I've got the general in there. Is there a life interest if they wanted to stay in the property? It's very unlikely, because obviously if the three of them are going, then you're going to sell the property anyway, because unless the guardian comes and lives there, generally you'll find that the guardian will go there. And that's one of the questions that you really need to put on touch with a client. You can do a spousal will in here, but I'm not going to worry about that at this present point in time. And then, of course, are you an account financial planner or estate planning advisor? And that would include, we'll soon have the Pepper advisor up there as well. You just tick yes as well, and put the name of your firm there. Testator is John Smith. We just picked that up from there. Do you want to appoint a professional advisor? Absolutely. So you put in here your details. What we will do is much the same as we do with SMSF wills, put your details in and the fees. So you can actually charge a percentage for administration or a set fee as well. So that'll be one of our next upgrades. The executors here, we've got, what we can do there is we've got Sally Smith, who's the spouse, who's the executor, and then I haven't got another one there because obviously Ben's not there. So I just drop into Mary. I'm going to add another. It's going to be individual. So I'm going to put John Jones here, which is their friend, and he lives in Brisbane. So I'm going to go back here. First executor is going to be Sally Smith. I'm not going to add another one there. I'll get rid of Sally there. So I'll just delete that repetition, which is what I'm doing. So I'll just delete Sally out of that because I've already got it once. Successor executor. Do you want to appoint a successor director? Yes. Who's it going to be? We'll make it John Jones there. And effectively, we've got that. Is this an overseas address? Yes. No. So, okay, so that's already got in there. So we've got John Jones in there. Second successor executor, I've got Joe Jones as well. So I can just delete that one and put in another one. I've actually mixed interview here. So sorry, it's a bit wonky, but anyway. So I just wanted to show you here just quickly. We've got specific gifts. The estate can pay the taxes. But for these specific gifts, we could, for example, have here the on-farm son Max, but in this one we can just have there, it's going to be Ben, and he's the child. He's going to get, for example, 1/3 of my estate. You can either do this specifically, and then do you want to go into a testamentary trust? Yes. Now what happens here is it's actually going to go directly to Ben rather than Sally. So 1/3 might be a bit much. We might just simply say we're going to pay to Ben 1/6 of my estate. And then is it going to go to testamentary trust? Yes. Is the main estate beneficiary the beneficiary of the testamentary trust? That means is Ben the beneficiary? Yes. Do you want the secondary beneficiary to be bloodline or lineage? Yes, because that would then get rid of any spouses or non-bloodline. Are there any related entities? No. Is the primary beneficiary the appointer? I would go yes. And then what you can do there is put in those terms and conditions. Remember we saw in that from that data capture, they're not to get income from so on and so forth. And then we can go Sally Smith. So she could get, Sally could get, for example, we might just leave it like that, but we could, for example, put in William, puts in the same, Mary's the same, so on and so forth. Then we can do our exclusion of persons. So I've got that no. Principal beneficiary, I've got Sally, and essentially there with Sally, she can just have the remainder of my estate. And so that's after all the specific gifts. So you can actually have the kids up there, specific gifts if you want, or just give it all to Sally. Now, if Sally's not alive, as you'll see down here, then it can be paid to the secondary beneficiaries and could cover, for example, the secondary beneficiaries could have the children there. So there's two ways of doing it. You can either make the children up front or alternatively can have them at the back end. So we're sort of running out of time, but we've got, that sort of gives the where we're at now with those testamentary trusts. Again, feel free to utilise the Abbott-Morley option. The best way for people to get is just to go to the Abbott-Morley website, isn't it, Tony, and then make a booking with you, which should be great.
Or they can just
a lot more of this. Yeah, so next week we'll have the full testamentary trust will be up and running for the trust deed. Then I'll start working on the family protection trust, and then I've got to obviously I'm going to draft up a quick hybrid trust on the weekend as well. So there's a lot of stuff going on, but again, you'll find that the learning we've got, and certainly you can do that SPEPA course will lift you up really high, is that the stuff that we're doing really, I'd have to say is I've never seen a lawyer in Australia do, or certainly accountants and planners, because we're looking at across a broad range of trusts that we can bring to bear for a client, as opposed to just throwing everything into the estate, which to me just doesn't make sense. Why put it all into the estate if you're going to have to wait 6 to 12 months to even touch it? Secondly, it might be contested. And what's the point of the whole thing? Why draft up a will if you know it's going to be contested?
Grant, if I can just say one thing here, a lot of GPS members feel a little bit hesitant to dip their toe in the water, and they're quite busy with the normal work as well. I just want to say that what you've just outlined, the second or third Abbott-Morley option, are fantastic. And just to refer everything to you and get a 30% of whatever's charged for your admin fees, I think that's genius. You know, so for anyone that's an accountant that just understands that how important this is, don't let other lawyers do this that don't understand it. If your client sees their suburban law, they'll do mirror wills where mum gets dad's money and vice versa. That's the worst thing ever. So using this tier 3 approach, I reckon, Tony and Grant, is just fantastic. I'll be telling GPS members about this. But secondly,
Yeah, go
Oh,
on.
sorry, Grant.
No, you go. No, I'm just saying in that instance also, one of the keys is remember at the back end of a goodwill, either with a family, if you go through this process, quite often we end up doing a family protection trust. So either that or through the testamentary trust, you're going to end up with 2 or 3 trusts that are new trusts for you to administer. So generally what you charge for the administration of a testamentary trust on an ongoing basis.
It'd be 1,500, $2,000 a year as a minimum, as an absolute minimum.
Yeah, exactly. So, if you have a look at that, there's some great ongoing work there as well.
The other thing I was going to say is, for years, I've been talking to accounts about asset protection and separating risk from assets. Yeah. But in the last 18 months, since you've brought out the leading member trusts and been working with Tony on this, I've been telling everyone and building in a change TPS, it's not about asset protection anymore. It's about the blend of the estate planning and asset protection. You cannot get asset protection right unless you take the estate planning into account as well. So to get everything done properly, it's great to have, okay, let's have a leading member trust or a company or super fund. That's great. But that's just the stage 1. Stage 2, most important, where does this go if mum or dad or if the key person dies? So you've got to build everything in at the same time, see the bigger picture. So love this approach. We're actually building some apps that will enable people to kind of, again, give these recommendations at the front end and then move through into one of these tiers once your clients understand. That won't be ready until next year, but we're working on them at the moment. I
know there's a lot of work going on behind the scenes, which I think is very exciting. And of course, the other one is that with that accreditation, once you get the certification, both Tim and I are directors of the Succession Asset Protection Estate Planning Advisors Association. So once you do that will also give you the ability. Again, we've still got to potentially use a tier 2 or tier 3 or tier 1, but it means that you're going to feel a lot more confident about doing all these sort of issues as well. And for the big, we generally find that tier 3, we end up doing some really big ticket guys, the ones that you're just worried about that have got 5 to 10 to 15 or 20 mil. And that's a good way for you to also learn that whole process as well. So, but it's great.
And as an accountant, sometimes they feel funny with pricing. I know Tony and Grant, you find pricing very straightforward because you know the value you're bringing to the page. So, if you're going to tell a client, who's worth 15 and 20 mil, look, it's going to cost 30 or 40 to get this done. Yeah. You'll be able to do that. And the accountant might find that a bit harder to do, but you guys are able to do that because you do it all the time. So that's another aspect of tier 3 to get the pricing right, because you guys are able to nail the pricing.
Exactly. Well, we tend to do really tailored proposals, and we don't give letters of advice. We actually, that's a good thing, is that we're not wasting our time doing a letter of advice. We're actually creating the documentation, and there may be like 15 or 20 documents to go through that process. So it's a lot more detailed, and it's also a lot more value there for the client as well. Last words from you, Mr. Tony.
Yeah, just piggybacking off you guys. Look, at the end of the day, it comes down to one thing, and that is the client's paying you to find a solution to their problem. That's why they're paying you. Simple, You don't. I mean, if you can't find a solution to their problem, don't take on the matter. Simple as that. Don't worry about it.
Okay, so there's a couple of questions here from John. I had an inquiry today about setting up a not-for-profit trust. Will LYD someday do a not-for-profit trust? We have actually got a couple of ones. John, if you want to, we haven't got them up on the platform yet, but maybe if you want to contact Tony, which is just Anamourlis, or just jump onto the website, you'll be able to contact him there, and he can help you through that process. It depends on whether the not-for-profit is like SPEPA, or are you going down the track to seek to get tax-deductible donations? Because they're really quite separate instances. I've just got to be careful. In a couple of years for not-for-profits, there's going to be quite a bit of administration, which isn't a bad idea anyway. And Daisy, Tony's just typing an answer there. If you want to refer a client, just get in touch with Tony, and effectively what will happen is we can go off and running there. But by the time Tony finishes, it'll probably be another hour because he's the slowest type.
The hanky. Where's the hanky?
I know. Anyway, thanks everyone for coming.
Thanks,
And
Grant.
we'll see you next week. Our next session is a whole week on effectively our trustees, and I'm really looking forward to that. And hats off, hat tip to Tim for actually bringing that to the best. John, if you just want to send me an email, and I'll look at it for you and go in, and we've actually got a specialist at Abbott-Family who does all those charitable tax deductible trusts as well. Anyway, it's Grant Abbott, Tony Anamourlis, and Tim signing off. Thanks a lot, guys, for
Thanks, everyone. See you all next week.
Okay, guys. Thank you.
Bye.
Bye.
Bye-bye.